Well, hello. This is Alan Kato. I am the owner and operator of my own law practice here in San Francisco, California, advising employers in all aspects of employment laws. And part of my practice is to help employers with respect to performance management, which may ultimately lead to an employee's termination. So today we are going to be talking about the issue of performance management and documentation so as to enable you, the listeners in the audience, the employers out there, to be able to first properly manage your employee performance problems. Second, to keep good documentation to hopefully avoid wrongful terminations and stay in legal compliance. And third, also achieve a reduction, if not an elimination, of abuse by employees who are not being properly managed and who will take advantage of employers' bad management practices by throwing up legal smokescreens to delay, if not stop, disciplinary actions by employers. So this is the agenda for this series of programs with respect to this topic. Now, I assume that all of you who are listening have access to the slide deck, and I will not read them to you, but we'll assume that all of you are reading, and I will be adding additional color to the points made in the slides. These are the topics that we will be covering during the entire set of programs. And with respect to what we'll be talking about today, I'm going to lead off with the presumption of at-will employment, which is a significant defense for all employers in all states except Montana. Now, this presumption, this legal presumption, is that employment may be terminated by an employer at will, without prior notice, and without giving an employee necessarily an opportunity to improve their performance. Now, I want to first of all say that there are certain exceptions to the at-will presumption. First of all, some of you who are not necessarily ones who have spent their entire career in the private for-profit sector will understand that, for instance, in the government sector, where some of you may have worked, civil service employees, for one, and another important segment of the population, the workforce, employees who are covered by a union collective bargaining agreement. Those are situations, again, government civil service or employees who are covered by a union contract, where the presumption of at-will employment doesn't apply. And in those situations, the employers generally must have good cause to terminate. So the first assumption I'm making is that, for the most part, you folks, the listeners in the audience, are all private sector, for-profit employers, and we're not going to be dealing with union employees. We're dealing with how to discipline and manage the performance of non-union workers. Now, having said that, even assuming that you have these employees where they are covered by an at-will presumption, in other words, that you can terminate them with or without cause and with or without prior notice, that presumption, the legal presumption, is rebuttable. Now, what does that mean? Well, it means that there are going to be situations where an employer and an employee enter into a contract agreeing that the employment can only be terminable for cause or good cause. Now, this may be intentional on the part of the employer in the sense that the contract may be expressed in writing, but more dangerous, and that's one of the topics that we'll be covering during the course of these programs, more dangerous is that an employer may unintentionally enter into a contract that limits or destroys the at-will presumption and turns the employment into one where the employment relationship may only be terminable for good cause. And how this happens is that the law recognizes, for instance, an implied contract that may be created by the employer by virtue of the employer making verbal promises and or by the employer's conduct, which may create an implied contract. And so some of the factors that may lead to an implied contract are listed in this slide, such as long-term employment, where there is praise by the employer about the employee's performance, where the employer gives the employee a promotion or bonuses and that sort of thing. So we're going to talk about how you, the employer, can avoid creating this type of an implied agreement, which often occurs quite unintentionally on the part of the employer. So the best solution to avoid losing the at-will protection is to have an at-will provision in your offer letter agreement and in your employee handbook, as well as in the acknowledgement that employers would have when the employee is first given the employee handbook, acknowledging receipt, and confirming that the employment relationship is at will. So this is the best defense to the possibility of creating either an express or an implied contract of employment that would be terminable only for good cause. Now, in terms of what do you need to say in your offer letter and or in your employee handbook acknowledgement? Well, you can use the language specifically listed in this slide that, first of all, that the employment is terminable at will, and you can just parrot this additional language. More importantly, that this at-will status is subject to change only by an agreement signed by the employer, and I always encourage identifying a high level or your highest level official of the company, such as your CEO. And then, last but not least, have and require the employee to sign the at-will agreement so that going forward there cannot be any dispute that the employee knew and agreed to the at-will nature of the employment relationship. So even in an at-will employment relationship, there are situations where you may not terminate the relationship at will. In other words, let's assume you have an ironclad at-will agreement. Now, this will protect you, the employer, from breach of contract claims in the event that you terminate the employee without good cause. But this at-will agreement will not protect the employer from claims that the employee was terminated in violation of laws that protect that employee's status. And so some of the examples I've identified are laws that protect an employee from unlawful discrimination, for example, on the basis of race or their religion, gender. The other common concern is to avoid violations, in other words, of violation of public policy. An example of that I've listed here is where an employee complains about workplace safety issues, and the employer then unlawfully terminates that individual for having complained in violation of OSHA. And last but not least, in a combination actually of both discrimination and public policy violation issues, is the notion that the law prohibits retaliation against an employee for having complained about some protected issues, such as complained about discrimination previously or some other public policy issue. So even in an at-will employment relationship, the employer is not allowed lawfully to terminate an employee in violation of certain laws where the employee is in a protected status. So how does the employer avoid getting into legal violations by terminating an employee who, for all intents and purposes, just happens to be in some protected category with respect to discrimination, or may have engaged in some type of protected activity? Having said that, that doesn't necessarily prohibit the employer from terminating that individual. It does, however, create risk that the termination can trigger a claim that the employee was terminated unlawfully for a discriminatory reason or in violation of some public policy. To avoid that type of claim, what I would suggest, and these are just broad categories that we'll talk more about, is first of all, consistency in how you treat employees in general, so that you don't engage in discriminatory practices of only disciplining the individual who has complained about some type of safety violation, but having consistently enforced your rules that may have been violated by this individual as well as perhaps others, and you have consistently enforced the rule by giving the level of discipline appropriate for that type of violation across the board versus just singling out the individual who engaged in some type of protected activity. The second general observation I would have that we'll, again, talk more about in the next couple of days is knowing when do you have to do something proactively to stay in compliance with the law. And we're going to talk about what that involves with respect to performance management. And last but not least, of always having a legitimate, non-discriminatory or non-retaliatory business reason for taking an adverse employment action, such as a demotion or termination. A common example that I would give you is, remember, I've mentioned the notion that employment is legally terminable at will, meaning that you can terminate for good reason or no reason. So, for example, I suppose that in an at-will relationship, I can terminate someone because they are wearing purple socks, because I don't like purple socks, and I don't like this particular individual because he's wearing purple socks. Well, frankly, nobody is going to terminate someone for that type of arbitrary and capricious reason. Rather, I'd suggest, and this is important for the legal compliance of it, that you would have some legitimate business reason to terminate that individual, primarily because, in most cases, the individual is simply not performing at a level of performance that is necessary for your business, and to then also consistently enforce whatever rule violations or performance standards have been violated by this individual, and also, if it is a high-risk situation, of taking proactive steps to make sure that the termination is going to be defensible in the context of a possible future legal claim if necessary. So at this point, I'm going to sign off, and then we will resume with respect to the next topic.